The chair will recognize himself for an opening statement. According to the Centers for Disease Control, 48 million Americans, or 1 in 6, will become ill from a foodborne disease each year. 128,000 people will require hospitalization, and 3,000 will lose their lives as a result. Sadly, many of these diseases and deaths could have been prevented if proper safety precautions had taken place on the farm, in processing facilities, and while transporting foods. The Food Safety Modernization Act, FSMA, the most far-reaching reform of the Food and Drug Administration's Food Safety Authority since the 1930s, was signed into law in January of 2011. The law tasks FDA with issuing major regulations covering such topics as preventive controls for human food and animal feed, produce safety, foreign supplier verification of third-party auditors, intentional adulteration, and sanitary transportation, among others. I am particularly interested in the sanitary transportation proposal released last Friday. Since mid-2011, I've been following stories about commercial food trucks without proper refrigeration, carrying perishable foods along our nation's highways at dangerously high temperatures, and a subsequent investigation by the Indiana State Police. Perhaps Deputy Commissioner Taylor can speak to how the proposed rule would address situations like this. I would like to commend Mr. Taylor for his outreach efforts and dialogue with all parts of the food supply chain prior to release of these proposed rules, and also for extending comment periods on issues unique to certain sectors of the industry, such as farmers. This conversation must continue. I believe the success of FSMA's implementation will rest on a flexible regulatory structure that, one, encourages an efficient risk-based approach to food safety, and two, acknowledges that a one-size-fits-all overly burdensome model simply will not fit such a vast and diverse food supply chain such as ours. In issuing its proposed regulations, FDA has released compliance cost estimates that differ significantly with outside estimates, and I would be interested in learning about the assumptions and methodology the agency used to arrive at these figures. Additionally, over the last few years, many parts of the food industry have voluntarily made progress towards preventing foodborne illness, and I would hope FDA would not punish these good actors as it seeks to bring the rest of the industry up to standard. I would also ask Mr. Taylor for a commitment to work with industry, particularly with respect to inspections, after the final regulations go into effect. A collaborative rather than adversarial relationship with industry will yield greater compliance and ultimately further our goal of making the U.S. food supply the safest it can be. Finally, while we need to finalize FSMA's regulations in a timely manner, I'm concerned by the court-ordered deadline of June 30, 2015. These regulations are too important to be rushed through without proper thought and consideration. I'd like to welcome Mr. Taylor, thank him for appearing before us today. I look forward to his testimony. And at this time, I'll yield the remainder of my time to Ms. Blackburn.
And we do welcome you and are pleased that you are here. Thank you so much for taking the time to be here and for giving us the opportunity to talk with you and to look at the FSMA and a look at food safety and FDA and the responsibilities that exist, the regulations, the guidance documents that affect the wide array of individuals and industries that are associated with our nation's food supply. Everyone wants a secure food supply, and they don't want it to be burdensome and cumbersome and difficult, and they want some certainty in the process. Since January 2013, the agency has issued a number of proposed rules and received a significant amount and number of comments. We hope we have the opportunity to review some of this with you today and look forward to making certain that we are all moving the right direction for food security. I yield back.
Chair, thanks, gentlelady. Now I recognize the ranking member, Mr. Pallone. 5 minutes.
Thank you, Chairman Pitts, and thank you, Mr. Taylor, for being here today. I appreciate the opportunity to check in with the Food and Drug Administration on its implementation of the FDA Food Safety Modernization Act, or FSMA. With the passage of FSMA 3 years ago, Congress gave FDA new tools to shift the food safety system from one that reacts and responds to food safety incidents to one that prevents them. FSMA provided the first major overhaul of federal food safety laws since the 1930s, and it was enacted at a time when the public health challenges of an evolving domestic and global food supply chain were evident in a series of foodborne illness outbreaks and contamination incidents. And I'm proud to have worked with my colleagues, Mr. Dingell, Mr. Waxman, and Ms. DeGette, on food safety legislation that emphasizes a prevention and risk-based approach to food safety from farm to table, both for domestic and imported food, and ultimately to have supported the passage of FSMA. Food safety is and should be a bipartisan issue, and I hope we in this committee will continue to do what we can to support progress in the modernization of our food safety system. We've seen in the last year the rollout of many significant parts of the law, including proposed rules for major framework elements such as produce safety standards, preventive controls, and oversight of food imports. I appreciate the work FDA has done in engaging with stakeholders and incorporating public input into the development of these proposed rules. However, I continue to urge FDA to enact final FSMA rules as expeditiously as possible because the safety of U.S. consumers' food supply should not be put at risk. In addition, the passage of FSMA did not end our work on protecting the public health from foodborne threats. There are 48 million Americans every year who get sick from foodborne illnesses, as estimated by the Centers for Disease Control and Prevention, and there are still several thousand deaths each year attributed to foodborne disease. In order to ensure that the safety benefits of FSMA will be fully realized, Congress must provide adequate resources to the FDA for implementation. The Congressional Budget Office estimated that the law could require $1.4 billion over 5 years to roll out, but the agency has received only a fraction of that in resource increases, not to mention the impacts of sequester. The food import user fee and food facility registration and inspection user fee proposed in the President's budget could also substantially support the implementation of a modern, effective food safety system envisioned in FSMA. I support the idea of utilizing such food-related user fees, which I believe can benefit both industry and government by reducing foodborne illnesses and the associated costs, which can be significant. The estimated overall economic toll of outbreaks is almost $80 billion annually. With the health and safety of the American public at risk, we can't leave the job only half done by not adequately funding FDA to fully implement this important law. And again, thank you, Mr. Chairman, and I yield back.
Chair, thanks, gentlemen. Now recognize the Vice Chairman of the subcommittee, Dr. Burgess, 5 minutes for an opening statement.
Well, thank you, Mr. Chairman, and appreciate, Mr. Taylor, you being here with us this morning and your willingness to discuss the implementation of the Food Safety Modernization Act and the shifting focus of food safety from reaction to prevention. I must say I am concerned that some of the rhetoric and initial goals for the process have not been matched by the proposed rules that have been released. The Food and Drug Administration did have substantial interaction with stakeholders initially, but it seems that the rulemaking process was only prompted to completion by actions in the courts. Therefore, I'm concerned that stakeholder comments were not adequately addressed in the proposed rulemaking. We should encourage the Food and Drug Administration to implement the Food Safety Modernization Act through a scientific and risk-based approach that addresses the needs and concerns of the companies that the laws affects. Many companies and industries in the food supply system have been proactive and have implemented innovative methodologies to address the changing landscape of the food supply system. Companies should continue to identify microbiological and chemical hazards and implement preventive controls to effectively mitigate risk. We should promote an environment that encourages innovation and moves away from a one-size-fits-all regulation. And let me just say, as we sit here now, over 3 years since the Food Safety Modernization Act was signed into law, I think it's significant that we're having this meeting, this hearing, in February of this year. Look, we all know what is going to happen when the weather heats up. We are going to have an outbreak. I don't know of what. I don't know where it will occur, but you've seen it. I've seen it through several years on this committee. We'll be talking about salmonella. We'll be talking about E. coli. I would like to know what is going to be different this year than has happened in previous years. What are you doing proactively with the new tools you have in the Food Safety Modernization Act that are going to allow us to perhaps predict and prevent, but at least mitigate the damage from these outbreaks that we all know will occur? Mr. Pallone talked about the fact that the Food Safety Modernization Act was necessary, first time it had been undertaken in decades. It was necessary because of the evolving nature of the global risk that was presented to our food supply. And as a consequence, we both know that evolving of the global risk has not changed. It's not diminished since the signing into law of the Food Safety Modernization Act. So if anything, it's even more critical this February than it was 5 Februaries ago or 10 Februaries ago. Our food supply system varies greatly across the United States. Certainly a one-size-fits-all approach cannot address the needs of U.S. food suppliers effectively. I hope we can continue to work with your agency and the stakeholders to ensure that the food supply system has the flexibility needed to allow the industry to tailor their programs to their unique product needs while also ensuring the highest food safety benefits for all consumers. Thank you, Mr. Chairman, for the recognition. I'll yield back to you.
Chair, thanks, gentlemen. Now I recognize the ranking member of the full committee, Mr. Waxman, for 5 minutes for an opening statement.
Thank you very much, Mr. Chairman. In December 2010, Congress passed the most significant overhaul of FDA's oversight of food safety since the passage of the Food, Drug, and Cosmetic Act in 1938. The FDA Food Safety Modernization Act, FSMA, we call it, represents a fundamental shift in how FDA approaches food safety, focusing on prevention instead of reaction. It requires food facilities to develop procedures to prevent food contamination and to take corrective actions when contamination is discovered. It requires FDA to establish standards for the safe production and harvesting of fruits and vegetables. It mandates increased FDA inspections for both domestic and foreign facilities and gives FDA access to records relating to food safety. It gives FDA mandatory recall authority and improves its ability to detain unsafe food. And it gives FDA better tools to oversee the safety of imports. It encourages FDA to work with other federal, state, local, and foreign agencies to more efficiently achieve food safety goals. It's an ambitious law, even just on an administrative level. It requires FDA to prepare more than 50 regulations, guidances, reports, and studies in a short time frame. Already, FDA has published proposed versions of the 7 most important regulations. Given their complexity, their need to fit together and complement each other, and the breadth of their reach, these regulations were not easy to develop. Their release is an accomplishment for which FDA should be proud. But now, of course, FDA must finalize them. And I recognize the political pressure put on the agency to delay and repropose. I also recognize the importance of ensuring that the regulations are workable and that they appropriately address the wide range of activities that they cover. But American consumers need FDA to act without further delay. We've all heard the statistics. According to the Centers for Disease Control, every year 48 million Americans get sick, 128,000 are hospitalized, and 3,000 die from foodborne diseases. The goal of the law is to substantially lower those numbers. American consumers will not get its full benefits until rules are all finalized, and that's why FDA needs to finalize them as quickly as the agency can. Mr. Chairman, I thank you for holding this hearing. It will be good to get an update from FDA on how the implementation of this extensive legislation is going. I hope FDA will share with us the impact the current lack of user fees is having or is likely to have on its ability to fully implement the law and protect public health. I would prefer that we fully fund FDA through appropriations. However, in today's political environment, that's not going to happen. Enhancing food safety is in everyone's interest, Republicans and Democrats, consumers, farmers, and manufacturers. We should be doing everything we can to give the FDA the resources it needs to make full use of its new authorities under the Food Safety Modernization Act. Mr. Chairman, I look forward to the testimony. I want to apologize in advance. There's another subcommittee meeting simultaneously with this one, and I may not be here for the full opportunity to hear the testimony. I'll try to get back for questions. Yield back the balance.
Chair, thanks, gentlemen. On our panel today, we have Mr. Michael Taylor, Deputy Commissioner, Foods and Veterinary Medicine, U.S. Food and Drug Administration. Thank you for coming. Your written testimony will be made part of the record. You'll have 5 minutes to summarize. This time, Chair recognizes Mr. Taylor 5 minutes for an opening statement.
Thank you very much, Mr. Chairman, and good morning, Chairman Pitts, Ranking Member Pallone, and members of the subcommittee. And first, thank you for convening this hearing, giving us an opportunity to discuss the implementation of the Food Safety Modernization Act. As you know, food safety is a fundamental public health concern, and it's a topic on which the public does have high expectations. And unfortunately, as many of you have noted already, too many Americans get sick every year, too many go to the hospital, and too many die due to foodborne illness. And the costs are high, estimated as high as $77 billion just in the costs associated directly with foodborne illness. We'll never have a zero-risk food supply, Mr. Chairman, but as the statements have indicated, most foodborne illnesses are, in fact, preventable. By preventing foodborne illness, we can improve public health, reduce medical costs, and avoid costly disruptions of the food system. And with food imports having risen many-fold over the last 2 decades, we need a strategy that also addresses the complexities and challenges of food safety in today's global food system. And fortunately, Mr. Chairman, FSMA provides us with that strategy. It is a risk-based prevention strategy that builds on what the food industry and food safety experts have learned works to prevent harmful contamination and reduce foodborne illness. FSMA recognizes the primary responsibility and capability of those who produce food to make it safe. It calls on FDA to issue regulations aimed at ensuring practical steps are taken throughout the farm-to-table system, as you've indicated, addressing produce safety, processing facilities, transport, and so forth. FSMA also provides FDA new inspection mandates and enforcement tools that we can use to help ensure high rates of compliance with FSMA's new standards, which is how we will achieve the food safety and economic benefits that motivated FSMA's enactment, getting high rates of compliance with the rules once they're issued. One of FSMA's most important themes, and one that we at FDA take very much to heart, is partnership. FSMA directs us to work with CDC to improve foodborne illness surveillance, with the Departments of Agriculture and Homeland Security to help get our standards right, and very importantly, with our state, local, territorial, tribal, and foreign government partners to support and oversee implementation of FSMA standards. In fact, the centerpiece of FSMA is the mandate to work with the states and our other partners to build a national integrated food safety system that will enable us to achieve our food safety goals more effectively and efficiently. We eagerly embrace these governmental partnerships in doing our work. We also believe strongly in partnership with the food industry and our consumer stakeholders. Our partnership approach has been demonstrated so far by the extensive outreach we have done to all segments of the food safety community, domestically and internationally, both before and after issuing the proposed rules that FSMA mandates. We've benefited enormously from innumerable public meetings, dialogue sessions and webinars with individual groups, and dozens of farm and plant tours where my colleagues and I have learned firsthand how food safety can be achieved on a practical basis across the great diversity of our food system. We're committed to sustaining this partnership and dialogue approach throughout the implementation of FSMA. As you know, Mr. Chairman, and as you've already acknowledged, we have issued 7 major rulemaking proposals mandated by FSMA, and when they are final, they will provide the framework for systematically building in prevention measures across the food system. I want to, again, produce safety, preventive controls, the things that you've pointed out. I'd be happy to answer questions about any of these rules, of course, but I want to highlight just very briefly some points about the proposals on produce safety and preventive controls, which we published January of 2013. As you know, the proposed rule on produce safety would require farms covered by the produce rule, and it's a targeted set of farms, to follow certain standards aimed at preventing microbiological contamination of fresh produce. The proposal on preventive controls would require facilities to have a written plan in place, to do modern preventive controls, have plans in place, verify that those controls are working. These proposals are grounded in practices that many in the food industry are already following. But as we seek to create a level playing field of standards through regulation, we fully anticipated that a number of challenging issues would arise. And that's why we have emphasized outreach and dialogue, and that's why we have received over 15,000 comments on the produce safety proposal and over 7,000 on preventive controls. And as I say, we've learned a lot through this process. That's why in December, we announced that we intend to publish and seek further comment on revised rule language regarding certain key provisions in the produce and preventive control rules on which our thinking has evolved. Through this process, we're confident that we can issue final rules that improve public health protections while minimizing undue burden on farmers and food processors. We also recognize that FSMA will only be as effective as its on-ground implementation of the final rules after they're issued. Our implementation strategy includes partnering with other governments to ensure appropriate and efficient oversight and compliance, but also a concerted effort prior to enforcement to facilitate compliance through education, technical assistance, and regulatory guidance. Now, before closing, Mr. Chairman, I must note the importance of finding the resources that FDA will need to implement FSMA in a way that achieves its important food safety and economic goals and meets the expectations of our many stakeholders. We have adequate resources now to issue the required regulations and conduct the mandated number of domestic inspections, and we will continue efforts to make the best use of the resources we have. But simply put, we cannot achieve FDA's vision of a modern food safety system and a safer food supply without a significant increase in resources. Last May, Secretary Sebelius submitted to Congress a report outlining the resources needed to adequately implement FSMA, including resources needed to retrain FDA and state inspectors, provide training and technical assistance to small and medium-sized farmers and processors, build the federal-state partnership, and very importantly, implement the new import safety system mandated by Congress. The import need is particularly acute, Mr. Chairman. We import 50% of our fresh fruit and 20% of our vegetables, and imported food shipments have increased from about 400,000 per year in the early 1990s to nearly 12 million today. But clearly our resources have not kept up with this incredible expansion of food imports. The need to improve import oversight was demonstrated once again in 2013 by significant outbreaks of foodborne illness involving the hepatitis A virus linked to pomegranate seeds from Turkey and the cyclospora parasite linked to produce from Mexico. Congress was right in mandating a new import safety system, which is needed to protect consumers and provide a level playing field for U.S. producers and processors. But we cannot do what FSMA mandates without the resources it takes to build the new import system. We're grateful, of course, for the resources we have been given through the 2014 appropriation process, which will be helpful in the near term. But I would also note that the President's 2014 budget request included authority, a proposal for authority to collect 2 fees that would also go a long way towards helping us meet our food safety obligations under FSMA, while also, we think, providing benefits for the affected industry and our state partners. One would address a registration fee for facilities that are registered with FDA. The second would be an import user fee, a minimal amount per entry that would provide resources to fulfill the food safety purpose of FSMA and also provide greater efficiency and predictability for importers. We look forward, of course, to working with you on those. I want to close, Mr. Chairman, and I appreciate the indulgence in going over the time, by just saying how gratified my colleagues at FDA and I have been by the strong expressions of support we continue to receive from our industry and consumer stakeholders and from the members of this committee for moving forward in implementing FSMA. It's important to get it right, and it's important to get it done. And in undertaking of this complexity, we know there will always be challenging issues, but we're confident that this collaborative approach that we've taken, pursuing this approach, we can resolve issues in a way that is good for food safety and workable across our amazingly productive and diverse food system. I look forward to your questions, Mr. Chairman.
Thank you. I will begin questioning and recognize myself 5 minutes for that purpose. Mr. Taylor, as I said in my opening statement, I've been waiting for FDA's sanitary transportation rule for some time. Since we passed the Sanitary Food Transportation Act, I've continued to hear some real horror stories about drivers turning off their refrigerator units to cut cost, and I called on the agency to expedite its efforts to address these serious problems. Can you briefly comment on the agency's recent proposal and what it will do to ensure food is safely transported from its producer or manufacturer to our local retailers?
Certainly, Mr. Chairman. We do consider the transport, safe transport element of FSMA to be an important part of the farm-to-table prevention strategy. Our science tells us that this is not the highest risk part of the food system by any means. We have fairly limited experience in recent years with outbreaks associated with transport. There have been historically major outbreaks. The Schwann's ice cream outbreak in the 90s made 220-some thousand people sick by virtue of inadequate sanitizing of trucks. But the rule that we have proposed under the FSMA mandate will ensure that there's clarity of responsibility among those who are shipping product, that is, who have produced the product and are seeking to have it shipped to a customer, those who are actually transporting the product, and those who are receiving it, clarity of responsibilities for ensuring that the right practices are taken across that transport part of the food system, including where it is appropriate and necessary to protect the safety of food, that refrigeration is maintained. And so, we focused in on the core elements that we think are important in transport. We think we've got a practical system that will provide this clarity of responsibility. Again, many in the industry are already doing these things, but we will fill in, I think, importantly, this part of the farm-to-table system.
Thank you. There are a number of unique issues related to the inspection of seafood processing facilities and imports from abroad. Can you please comment on the various programs FDA has in place to oversee our global seafood supply, as well as recent improvements made to these systems?
Certainly, Mr. Chairman. Back in 1996, actually, FDA issued so-called HACCP regulations, essentially preventive control regulations for seafood processing facilities, both in the United States and overseas for facilities shipping product to the United States. And this is the modern approach to preventive controls that FSMA has mandated for the entire food supply and that we're working to implement. And so we have a long history of implementing modern preventive controls for seafood. We do import 80% of our seafood, and so the oversight of imports is a crucial part of the system. The system includes a responsibility for the importer to verify, have some verification from the foreign supplier that they're implementing modern preventive controls. But we also prioritize in our foreign inspection program seafood facilities because we do want to verify that these modern preventive controls are being implemented, and we target facilities based upon the information we know about where potential hazards might be. We also have, under the existing law, the authority to stop product when it comes into the country. This is a reactive system, and it's not the prevention system that we'll ultimately have when FSMA is implemented, but we have strong authority. We've used it frequently with respect to seafood to detain product from facilities or even from countries where we have repeated violations of issues like animal drug residues or other matters of concern from a food safety standpoint. So we have a solid program. We will continue to work to improve it, but it's based upon the modern prevention principles that now FSMA is mandating comprehensively.
Thank you. The committee appreciates the agency's efforts in this regard and is committed to ensuring that unnecessary and duplicative programs do not hamper such efforts. Provisions added to the Farm Bill at the last minute, expanding the Department of Agriculture's catfish program, would do just that. I agree with GAO and others that while doing nothing to improve safety, this program is a waste of taxpayer dollars and would increase compliance costs across the seafood industry. Understanding the complexity of the issues involved and the diversity of those impacted, I appreciate the agency's extension of comments, particularly with respect to the produce and preventive control rules. Can you comment on whether the court-ordered deadline to finalize these major rules has hindered your agency's ability to continue what I consider an essential dialogue with the regulated community?
Mr. Chairman, we don't feel that the deadlines have hindered that dialogue. The deadlines are a challenge, but we are organized and focusing our efforts to meet those deadlines. We believe we can do it. We think our ability to reopen the comment period for some comment on some of the key issues of concern will advance the process. But we will have to be very efficient and work very hard to meet those deadlines, but we're committed to doing it.
Chair, thanks, gentlemen. Now I recognize the ranking member, Mr. Pallone, 5 minutes for questions.
Thank you, Mr. Chairman. And I want to thank you, Mr. Taylor, for coming here today. I know that Congress gave FDA a big job to do when we passed FSMA, so I'm going to ask you to give us a sense of the scope and diversity of the new responsibilities that FDA is directed to undertake
Yeah.
in about a minute or so. 'Cause
Yeah,
we have
well,
more questions.
but it is just for a practical matter. It is really about creating comprehensively a new system of prevention. It's a new food safety system, beginning with what happens on farms where we've never regulated for produce safety before, going all the way through processing and transport, and then recognizing we have to manage global supply chains. So it's an entirely new import oversight system. So it's a massive undertaking. If you just read the law and count up the deliverables, as I think you indicated, it's a huge task, and it is requiring us to mobilize everything we've got now and to figure out, and be very clear about the resources that we'll need to carry it forward to successful implementation.
Well, thanks. I touched in my opening statement, I said that CDC estimates that 48 million Americans get sick, 128,000 are hospitalized, and 3,000 die each year from foodborne illnesses. And these numbers show that this is a serious problem that can be devastating for families. Let me ask you two questions. What are the impacts on consumers who contract a foodborne illness, and how will FSMA benefit consumers and reduce the burden of foodborne illness?
Yeah, Mr. Chairman, some people think that foodborne illness is just an upset stomach, and maybe many of those 48 million cases are transitory illnesses. They do add up to a big public health burden in and of themselves. But many foodborne illnesses are devastating, lifetime, damaging experiences. People lose organ function. People's lives are changed forever, and incurring not only great suffering on their part, but big medical costs. And then 3,000 people die. So, it's more than a transitory stomach ache. And again, the whole idea here is to build in the practical preventive measures that can stop E. coli and salmonella and other pathogens that can make people sick from getting into the food system, and doing that in the most practical but systematic way possible. And by doing that, again, we're not going to eliminate foodborne illness, but we can substantially reduce these illnesses and benefit consumers. These illnesses are largely preventable, and I think what people expect is that we do everything we reasonably can to prevent them, and I think that FSMA is the mandate and the system to do that.
Well, I'm going to get into the resources issue because you mentioned that, and that's obviously very relevant. FSMA gives FDA many new tools to use to improve the safety of the food supply. However, I'm concerned that you'll have a hard time making full use of them without added resources. The agency's report to Congress last April on domestic capacity building to implement FSMA mentioned there's a gap in funding needed to fully implement the law, and it briefly discussed how the authority to generate new user fee revenues would be used for food safety. And as you know, the food safety bill that the House passed in 2009 did include facility registration and importer fees to increase resources. Would you just comment on what the food-related fees proposed in the President's fiscal year 2014 budget would be used for if Congress gave FDA the authority to collect them? And how would the absence of user fee revenue affect the agency's ability to continue to implement FSMA?
So there are two fees, as I mentioned. One is a facility registration fee. Those resources would be focused on improving inspection and being sure that our inspection force is trained and prepared to work under the new modern preventive system. So training for inspectors would be a big part of that. Those resources could also be used to support the federal-state partnership. We think we can be more efficient and effective working closely with state partners who already conduct some inspections for us. They need their own training and capacity building. The import fee would really be the key to building the new import system. We're mandated to establish this foreign supplier verification program requirement, but that puts us in the position, which we want to be in, of auditing complex supply chain management systems. We need a whole different training and orientation of a frontline workforce. We need staff to do that work in addition to actually checking product coming in at the port of entry. And then very importantly, Congress, and I think wisely, mandates us to be much more present overseas, to work with foreign governments, to do more foreign inspections, to see that preventive measures are being taken offshore. So it's really building that new import system that the import fee would be crucial for.
All right. Thanks so much. I guess I still have a few minutes. Let me ask about, I know that seconds. The chairman mentioned the catfish, and I'd like to know, has FDA found catfish to be a high-risk food, and can you describe for us the system FDA has in place for fish and food safety, and whether FDA has found that catfish pose unique or special risks warranting special oversight?
Yeah, well, certainly the reason we issued the HACCP rules, the preventive control rules for seafood, is because seafood, if not handled properly, can present concerns. But within the seafood universe, we actually think catfish is on the lower end of the spectrum of potential risk. It's not sold in a form that's ready to eat. A smoked product, for example, is more risky. It's not consumed raw generally. And we don't have a history of outbreaks associated with catfish.
All right. Thanks again.
Chair thanks the gentleman, and now recognize the gentleman from Illinois, Mr. Shimkus, 5 minutes for questions.
Thank you, Mr. Chairman, and welcome, Mr. Taylor. So in this full committee and on our various subcommittees, it's amazing how some things reoccur, even in the different. So my discussion is going to be, I'm going to use the term recycling, but as we found in other sectors, we force ink producers to throw away ink instead of bringing them back through the process because of rules and regulations. As we heard yesterday, we force electronic manufacturers to throw away their boards instead of recycle them because of rules and regulations. So this is the first question. On in the process of commodities are already safe for human consumption that goes through the process in the front end, and let's just take barley that's going to go into production of adult beverage beer. Then it goes through the process, but then there's always obviously the remaining ingredients after the process has occurred. Many times that then is used in animal feed issues. Now there's a concern is developing that if in this process then FDA then forces that end use muck that's been used in animal feed to then go through another inspection process to see if it's safe for the feed processing in animal feed, then you will do the same thing that we did with ink, and we did the same thing we do in computer boards. We will then add an additional burden in disposal, and then we'll take away a commodity product for food processes. That's a concern. Can you speak to that?
Sure, Mr. Shimkus. We're aware of this issue, and of course we have proposed a preventive controls rule for human food facilities and a preventive controls rule for animal feed and animal food facilities, based on the same principles that the law lays out. But there are differences in the way in which human and animal feed need to be handled for safety purposes. So we have two separate rules, but they have to fit together, and they have to work in a way that does not disrupt this practice. We're very aware of this relationship between human food and animal food production, and we don't see any reason from a food safety standpoint to disrupt that at all. And we'll, based on the comments that we are getting and we'll get on this, I think we can harmonize these rules and avoid the concern that you're raising. I'm confident about that.
Okay, so you understand the concern,
Yes,
and our basic premise is if it's in the entry point, say for humans, understanding you've got to figure out the end point and the processes, but it should be safe for animal feed for the most part, unless. Right.
Again, the system is all about being risk-based, and it's about not duplicating effort. And so there any number of ways in which we're being very careful to be sure that we're getting the control we need, but not having duplicative controls.
But you don't know of any record of in that process of animal feed through that process has caused any human health indications. There's been no report of to anybody that there's been any incident.
I'm not aware of it sitting here. If others are, we'll put that in the record.
Well,
but
I don't think there is either, and that's the point of the debate. So
thank you.
Appreciate it. Let me also then go to there's a great deal of variability in food products and processes, as you know. Therefore, a successful testing program is tailored to a specific circumstances related to each product and manufacturing operation. How will the regulation be written to assure that testing is risk-based and not prescriptive? Very similar to the other previous question, but this is really just in the initial food supply.
That's very important. I think we all know from long experience that certain kinds of testing programs in certain kinds of facilities can be important to verifying that controls are working. Peanut butter processing facilities, for example, where salmonella in the environment can contaminate peanut butter and cause a significant problem. Most companies undertake so-called environmental monitoring, testing of the environment to verify that the sanitation and other measures are preventing the presence of that pathogen. And so, but it's also well understood that those testing programs have to be based upon the particular risk considerations, the processing systems and the products in that particular facility. There's no one-size-fits-all solution. Right. And I think if we're agreeing on anything across the board, one-size-fits-all doesn't work on any dimension really here.
Well, and I think that's what we find out on our committee, and going back to the hearing yesterday on another subject, risk-based is where we need to be. And really the private sector, if you evaluate their testing processes and you find that it adequately does the test, the concern is government will be prescriptive. Yeah. And they'll say, test it this way, right, where we know that the industry's already got a pretty good process of ensuring safety and efficacy.
And if I may just really briefly, I mean, we know there are firms that have invented the standard of care, if you will, or have programs that are in place and are doing the right thing and, in fact, may go beyond what we would end up mandating. We have to have rules that are flexible enough to not disrupt those ongoing practices, while also setting a standard of care that's clear and implementable by those who aren't there yet and who FSMA is intended to bring up to an appropriate standard. So that's the balance we need to strike in the final rule.
Thank you very much. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. Now recognizes Mr. Matheson. 5 minutes for questions.
Well, thank you, Mr. Chairman. I appreciate the committee holding this hearing. I think this is a good thing for Congress after it passes a law to take a look at how it's being implemented. I think that's something we ought to do a lot of in Congress across all committees, so I do appreciate this hearing. Mr. Taylor, I've heard some concerns raised, and this may have been covered a little bit before, but I'm going to ask you again anyway. I've heard concerns raised about the language in the proposed rule on the preventive controls. Some have raised the concern that the phrase reasonably likely to occur in the rule is different than the congressional intent, which would be reasonably foreseeable. That's in the law. That's the term. Mm-hmm. Can you talk about these concerns, the validity of these concerns, what these different, to me, these are two different sets of language, and I don't want to get into semantics, but sometimes it matters. So can you talk about that, about what that means?
Sure, and I think we don't need to go into a lot of detail to sort of get, I think, what is the essential important point. It's the one that we were just discussing. Right. The concern really arises from folks whose systems are advanced, they're established, they're clearly achieving the sort of prevention that FSMA is about. And we want to be sure that we don't use language in rules that would create a concern about forcing change in those practices that don't make a practical difference for food safety. And we've had a lot of dialogue with industry stakeholders, particularly on this point. We think there's a way to solve this, to manage this, so that we achieve the purpose that I just recited. We need flexibility for them, but a standard that we can implement and enforce where needed for those who aren't there yet.
So to the extent you've heard concerns raised about this, you're trying to work with stakeholders right now to figure out a way to get
absolutely.
We're
have very active dialogue. This is a solvable issue.
That's great. Yeah. That's great. Next question I'd ask is the law asks for an increase in the number of domestic food facility inspections. Do you have any indication of how many inspectors that's going to take and what the costs are going to be for this?
Well, I think one of the things that is fortunate is that with the increases that have happened over the last few years, we feel that we have the number of people we need to meet that domestic inspection frequency mandate. Okay. So that's a part, of FSMA where we think we can do, hit the number. What we don't have is the resources right now to retrain and to re-equip those inspectors to work in this sort of modern preventive controls environment where we want to be focusing on the public health outcome and not just a checklist of regulatory requirements. So we need that, and then
do you have those resources, by the way?
We don't have that. I mean, that's the kind of additional funding that we need in order to implement FSMA successfully to really get the full modernization benefit that FSMA is about.
Do you have a sense about what that gap might be?
I'll stick with the request in the President's 2014 budget, and that it included about $225 million in fees, which would go a long way towards closing the FSMA funding gap. The total FSMA funding gap that Secretary Sebelius recited to Congress in the spring of last year was $400 to $450 million above our 2012 base. Okay. We took a step back in 2013. We took a step forward in 2014. We still have a sizable gap.
Do you plan to use third parties to conduct some of your inspections?
No, sir. We will partner with state governments and other governmental partners on inspection. We do see the value of working to strengthen the private audit system that the industry has developed over the last number of years. And The law itself, as you know, mandates that we establish an accredited third-party certification program for certain import oversight purposes. They're fairly narrow and targeted, and would not. But we would not ever think of private audits as a substitute for our inspection.
For the ones that are not domestic, for the ones overseas, would you be looking at how's that third-party system implemented so far? How's that
The
going?
way in which Congress has prescribed that accredited third-party auditors be involved in certifying the safety of imports is in two situations. One is as part of the so-called Voluntary Qualified Importer Program, which is the expedited entry system for people who are going the extra mile. That would include an accredited third-party audit of the foreign facility. We also have the authority to mandate an accredited third-party audit for particular high-risk situations. But those are the specific uses for which the accredited third-party audit is in the law.
Okay. All right. Well, thank you for your answers. And, Mr. Chairman, I'll yield back.
Chair, thanks, gentlemen. Now recognize the Chair Emeritus, the full committee, Mr. Barton, 5 minutes for questions.
Mr. Chairman, thank you. I'm going to yield my time to Mr. Waldron of Oregon.
I thank the Chairman Emeritus, and I thank the Chairman for holding this hearing. And Mr. Taylor, it's good to see you again. I've appreciated the meetings that we've had with you and your team, and your openness to taking a look at how some of the ag practices actually occur on the ground and may be in disconnect with the original rules. And appreciate your coming out to the Northwest and bringing your folks to meet with a lot of our growers out there, especially on the east side of my district, with the onion growers who actually are having their annual conference about now, and to witness firsthand how irrigation works and the kill step in growing onions and safety of how they do it. So I was really pleased you were open, you listened, you pulled back the regs that would have been in conflict and moved forward. So I commend you for that. And I hope the science that our OSU lab produced out there on this issue involving onions was helpful. I sense that it was in your decision making. My question relates to as you go about redrafting the rules and what interactions you might be having with farmers and ranchers out in the West, certainly in districts like mine, and as you write these new rules. Obviously, that continued communication is important to the extent it's allowed under your rulemaking processes.
Well, thank you, Ms. Walden. And the trip to your district was just a great learning experience for all of us. We appreciate the hospitality that you and your colleagues there showed us. But yes, when we reopen the comment period and publish proposed alternative language on certain key provisions, there will be at that point an opportunity to have not only written comments, but to engage directly with people who will have perspectives on what we've reproposed. And we will be reproposing on the water standard, including the standard itself and the testing regime we propose. So there will be interest, no doubt, in your community. We look forward to whatever dialogue would be useful. And the research that's going on in Oregon at the university, is helpful work, and we're collaborating closely there. And I think we can address the concerns that we heard about out there.
And as you know, there was some language in the Farm Bill that dealt with some of these issues around the rules in terms of the economics and I think in terms of science as well. Obviously, it's critical that we get a science-based set of rules that actually work in the real world. I know when I was out and met with our onion growers, toured around as you and your team did at another time, they were just pointing out how from field to field you could have radically different readings for no real reason that it was even manageable. And meanwhile, I think one of the growers told me they'd been growing onions there for 100 years and never had an outbreak of salmonella. And they bagged, I don't know how many millions of bags every year. I thought that was a pretty big sample size if you were going to do a statistic analysis of risk. And so I appreciate your pulling back on those rules. It's just essential, whether it's there or our cherry and pear and apple growers or blueberry growers, that we get this right and not upend them. And, of course, they have concerns about imported foods having to, do they meet the same ag practices we're putting on American farmers? And we got to be careful. None of us wants spoiled food. None of us wants the illnesses. I actually helped lead some of the investigations into Peanut Corporation of America, but that was a case where they did things that were against the law to begin with, and they're paying a very severe penalty, as they should, for their actions. So we want to make sure we've got this balance right between safety of our food supply that allows for productive agriculture to continue in a way that works. So again, I thank you for listening to us and actually coming out on the ground, and I hope that as we go forward with those rules that there will be plenty of time for our folks that are going to have to abide by them to have full input.
Absolutely. We're all working towards the same goal, and we'll get there by working together, so we look forward to that.
Thank you. Mr. Chairman, I yield back to the chair.
Chair, thanks, gentlemen. Now I recognize the Ranking Member Emeritus of the full committee, Mr. Dingell. 5 minutes for questions.
It is important, as a matter of fact, urgent. And I'm pleased that the subcommittee is conducting proper oversight of this important law. This is the way oversight should work. The Food Safety Modernization Act was a strong bipartisan response to the globalization of our food supply and to the numerous tainted food products coming in from abroad. It was clear that FDA needed new innovative authorities to ensure the safety of imported foods. It also needed money and personnel to do its job. FSMA was a significant step forward, but we have a lot of work left to do. The CDC estimates 48 million people get sick from foodborne illness each year. Furthermore, 128,000 people are hospitalized and 3,000 at least die. Although we are not going to get these numbers down to zero, we must continue to focus on improving food safety in this country, particularly that which comes in from abroad. While FSMA represents a significant increase in authority for the FDA, Congress has only solved half the problem. We also need to give FDA the resources it needs to fully implement FSMA and to create a proper, adequate 21st century food safety program. Mr. Taylor, I request that you answer these questions yes or no. Does FDA have the resources in money and personnel it needs to properly implement the Food Safety Modernization Act? Yes or no?
No, sir.
I would appreciate it if you would submit to us a proper survey of what you need in the way of money to accomplish this purpose. The Obama administration's fiscal year 2014 budget request included $59 million in food facility registration fees and inspection fees and $166 million in food import fees to help fund food safety activity. Does FDA continue to support user fees to pay for FSMA, yes or no?
Yes, Mr. Dingell.
Congress gave FDA a big job to do, but clearly not enough money to do it right. I would note that the House-passed version of FSMA contained user fees that would have helped solve the problem, but this provision did not make it into the final version of the legislation. Many stakeholders continue to have concerns both about the timing and the substance of FSMA regulations. I would posit that these issues may not have been a problem if we had done the right thing early on and given the FDA the resources that they needed. Today, we find FDA under court-order deadline to finish all FSMA regulations by June 2015. Do you have the money to do that?
Yes.
You do?
To get the regulations issued, yes, sir.
All right. Passage of FSMA was the product of collaboration between industry, consumer groups, and the agency. And I think the industry deserves commendations for the fine work they did on that matter from start to finish. I hope that this process will continue as FDA moves forward with the finalizing of these critical regulations. Next question. Mr. Taylor, will FDA commit to working with all stakeholders and considering public comments as the agency works to meet the June 2015 deadline for issuing final regulations?
Yes, absolutely.
Or no?
Yes.
Now, one critical part of FSMA is increased inspections of both foreign and domestic facilities, food facilities. And FDA will need to hire more inspectors to properly do the job. And I happen to think that we desperately need more inspection of foreign producers and more scrutiny and surveillance of foreign producers and others who enter the food supply chain. Is that a correct assumption?
Yes, that oversight is important.
Yes or no?
Yes, sir.
Now, FDA will need to hire more inspectors to properly do the job. Is that right?
Yes.
And you're going to have some more for overseas?
Yes. We
Now-
have the resources for domestic, but not for overseas inspection.
Does FDA have the resources to meet the hiring targets set by FSMA? Yes or no?
Yes for...
You do?
No.
You do not have
Not
the resources.
those targets in the law, we do not have the resources to meet.
I don't want the record obfuscated on this matter.
Yes.
Will you submit, please, a detailed response for the record, including the resources you need and how many FTEs or full-time equivalent employees FDA needs to hire?
Yes, we will.
And how many do you plan to hire?
Well, our plan will be a function of the resources we get, and we will
Submit it-
lay that out
submit
in
that
the
for
response.
record,
Yes, sir.
If you please.
Yeah.
FSMA also contains some exciting new authorities that are already in place and are protecting the American people, including mandatory recall of tainted food products. That's a new authority to the agency. Is it working?
Yes.
Does it need change?
It works.
All right.
We don't think it needs change.
Has FDA exercised a mandatory recall authority under FSMA? Yes or no?
Yes, we've initiated the process twice. The firms have wisely, voluntarily recalled once we invoke the
They
mandatory
didn't.
authority.
They didn't
So-
fight you on the recall.
No, sir. That's the power of this authority. Is that
Are you comfortable that the authority is sufficiently sweeping and adequate to carry out your responsibilities there?
yes, within the food part of FDA.
If food.
Yes.
Now, you do not have the authority with regard to pharmaceuticals, do you?
That's correct.
And how about other things like devices, knees, hips?
You're leading me out of my territory.
Say again?
But there are gaps in FDA's authority on the medical product side with respect
All right.
to mandatory recall.
I want to thank you for this. I believe that mandatory recall is a useful tool in any emergency and should be expanded to the other areas that we have just been talking about in the agency's jurisdiction. Now, FDA has a large task ahead of it as the agency works towards final implementation of FMSA. I urge the agency to move quickly during the rulemaking process while continuing to engage in a collaborative process with the stakeholders, because working with the stakeholders will be the way that you will get their support, their wisdom, and the ability to do your job better.
Yes, thank you,
Mr.
sir.
Chairman, you have been most courteous in giving me extra time, for
Chair.
which I thank you.
Chair, thanks, gentlemen. Now I recognize the Vice Chair of the Subcommittee, Dr. Burgess, 5 minutes for questions.
Thank you, Mr. Chairman. Just listening to that exchange with Chairman Dingell, it took me back to the heady days when he took the gavel from Mr. Barton. And in fact, if you look back at that time, the budget for the Food and Drug Administration was about $1 billion, and today it is more than that. Is that a fair statement?
Yes.
It's about 2.5 times that amount.
In budget authority, yes.
So
That's for the agency as a whole, not for the food side of
Correct.
the agency.
Correct. But even with the sequester, the Food and Drug Administration received from Congress an increase of nearly $100 million over the amount provided in fiscal year 2013. And in fact, you got several $1 million over the agency's budget request. Is that not a true statement?
We got what we asked for on food safety to implement FSMA, yes.
Okay, so nearly $1 billion, $900 million was targeted to the Food Safety Network. Is that correct?
Yes, sir.
So, Mr. Dingell was talking to you about he wanted some detail on the resources that you think you might need. I guess that means resources in addition to that $900 million was what he was asking for. But can you provide us the accounting of how the $900 million has been spent so far that was targeted to the Center for Food Safety and Applied Nutrition?
Well, and we can do that. Just to be clear, that $900 million you're referring to is total funding for all food-related activities at FDA. We have certainly deployed a huge part of that to FSMA implementation, but those resources also cover what we do in food additive regulation, in nutrition, dietary supplements, a range of other programs that we're responsible for. That's not all for implementing the Food Safety Modernization Act, but we can certainly provide you that information.
Could you provide us that with
Yes,
the
sir.
level of details? So
Certainly.
we'd be able to, the key here is discernment. Chairman Dingell asked you for what you might need in the future, but I'd like to know what's being given and what's being spent and how it's being spent.
Yes, indeed.
Currently. Let me ask you, because he brought up the issue of foreign suppliers, the scrutiny of foreign producers, I think was the terminology he used. How are you organized or structured to make certain that there is that fairness that he was talking about, that we are not discriminating against local producers at the or advancing foreign producers at the expense of local producers?
Sure. So the answer to that is being able to implement the full FSMA import toolkit that we've been given to create this new import oversight system. The foundation for it is the Foreign Supplier Verification Program requirement, which makes the importer accountable for having a plan through which they can document that they know where their product is coming from, their imported product, and they can verify in an appropriate way, based upon risk, that the proper controls have been implemented at the foreign supplier point. That private sector responsibility for supply chain management is the foundation for this new import system, and it's much more preventive and, again, reliant on industry. It will work, though, to the extent that first we can have people who are trained, and we have adequate numbers of people to check that those systems really mean something, that they're not just words on a page. So verifying that those audit systems are working.
And I think that's the key, because we certainly heard through hearing after hearing after hearing in 2007 and 2008 and on into 2009 about where the problems existed, and there were imports that were coming in that had no business coming in. Are we better prepared today to deal with those problems?
Well, we're building the system that will enable us to be prepared if we can.
We're not there yet.
No, we're not there yet. I mean, again, I think there's FSMA has stimulated a heightened recognition and reflects a heightened recognition as well across the food system that we need to be improving how we manage supply chains globally as well as domestically. But FSMA won't fulfill its purpose until we not only have the regulations promulgated, but until we can actually verify that system is working. And again, Congress.
My time's running out.
Yeah,
what are the barriers to promulgating those regulations right now?
It's just a lot of work, a lot of issues. We're deploying the people to do that. That's our priority is to get those rules done.
But when this legislation was passed by Congress in 2010, the promise was that we were going to prevent these problems that had been happening with such alarming regularity, that we were going to protect the American people, that the FDA had not been able to keep up with the effects of globalization, but that was going to change. When can we tell people to expect that change we can believe in to have happened?
FSMA will fulfill its purpose when we are able to implement it, and it's not just the rules, it's the ability to oversee the rules. So it's a process that over the next several years will have the benefit that you seek, but it's not an overnight process to build a modern food safety system for this century.
Several years, meaning it could be a decade.
I think, it won't be that long before you'll have rules in place and the ability for us to verify that those rules are being implemented if we get the resources to
I hope not, because the decade actually would be 2020. That would be the 10 years from the passage of the Food Safety Modernization Act.
Yes, sir.
Thank you, Mr. Chairman. I'll yield back.
Sure, thanks, gentlemen. Now recognize the gentlelady from California, Ms. Capps, 5 minutes for questions.
Thank you, Mr. Chairman. Commissioner Taylor, I thank you for your testimony, and I'm glad to be here today ensuring that the Food Safety Modernization Act is and continues to be as effective as possible. I understand that the FDA faces immense scope of responsibility in implementing the Food Safety Modernization Act. You mentioned that FSMA will only be as effective as its on-the-ground implementation lets it be. And I agree. Agriculture is one of the primary economic drivers in my district, and so these issues certainly hit close to home. Food safety for fresh produce, such as leafy greens, is obviously incredibly important. As you may know, following an earlier food safety crisis in 2007, California leafy green growers, many of them are in my congressional district, took it upon themselves to raise the industry safety bar by creating the California Leafy Green Products Handler Market Agreement, a mouthful, LGMA for short. Since its founding, LGMA has become a strong collaboration between government and farming communities. They incorporate science-based food safety practices and mandatory government inspections in an effort to ensure safe leafy green products. The LGMA has already been, for all intents and purposes, verifying the leafy green industry's compliance with food safety practices that meet or exceed the specific rules being proposed under FSMA. Obviously, we all want to make the process as efficient and effective as possible, ensuring high standards without creating unnecessary redundancies. I just met with the California Farm Bureau folks, a couple from my district, just now. This is very much on their mind. So my question to you, can you tell me what the agency is doing to collaborate with groups like LGMA in this process? How will FDA work with industry to verify compliance with the new FSMA laws?
Yeah. Well, thanks very much for the question. The Leafy Green Marketing Agreement is a real demonstration of leadership on the part of that industry,
yes,
which has come about in response to some of the outbreaks that were very costly and disruptive for that industry. And the standards that they have put in place and that they monitor themselves are very positive and are standards that, as you say, will likely meet or exceed, what the federal standards will be. And we certainly, as we think about how we verify compliance with this broad range of standards, absolutely want to cooperate with and place reliance where appropriate on these private efforts to monitor and verify and demonstrate that their product is being produced in accordance with these standards. So we meet with, we collaborate with the folks involved in the Leafy Green Marketing Agreement. It's a very positive part of progress on food safety, so we embrace it.
So it's not like one person has the rules and the other person is trying to comply, but you are all in it together.
Enormous dialogue and recognizing that we want to capitalize on what people, leaders in the industry have learned and then again, not disrupt those practices that are working, just,
right,
out of some, yes.
Let me just push this a little further. Not that I don't disagree with what you're saying, but as you know, unfortunately, contamination in our food supply repeatedly has threatened the health of Americans over the years, and you mentioned how costly it is to the industry as well. These events have really initiated such fear in consumers concerning the safety of our food supplies, the very food that is the best health best for us. So we need more of a win-win. And I think that's behind this effort here, bipartisan effort to enact the Food Safety Modernization Act. Now, several years post-enactment, how have we become more prepared? Do you think we are in a position where we could not just prevent but anticipate the next big outbreak? How will the FDA be more effective in dealing with the next big food contamination emergency?
Well, I think there are a couple things. I mentioned already that I think the FSMA is part of a process and where we've been making progress in the private sector and through collaboration between government and private sector to put in place practices even as we anticipate FSMA being implemented. And that's one way in which I think we're hopefully making progress. We have also done a lot of work at FDA and with the CDC to be better at detecting outbreaks earlier. We've created a focused, specialized team at FDA to do early detection of potential outbreaks, to respond more quickly, and then importantly to learn from outbreaks. And so we've investigated, for example, the cantaloupe outbreak that killed 33 people associated with listeria in cantaloupe. We did an investigation of what the potential cause was, and then we've been out collecting additional data to inform the cantaloupe industry about measures that can and should be taken. So there's a lot of work going on, and again, which will continue even as we get the regulations in place and are able to verify that the practices that we're learning work are in fact being implemented comprehensively, not just by the leaders, but comprehensively across the system.
Okay, great. I'll yield back.
Gentlelady yields back. Dr. Murphy for 5 minutes.
Thank you, and welcome here. Appreciate your testimony. It's very enlightening. I'm wondering, the CDC a couple years ago said that there was a reduced or different risk in foreign imported products versus the United States. Does that difference still exist?
Yeah, it's the data that permits you to be very quantitative about this are limited, but CDC did report increases in significant numbers of outbreaks associated with imports, and so we know that food can be jeopardized whether domestic or imported, but imports are very much a public health concern.
I'm just curious then, is there a difference in seafood, meats, fruits, vegetables in these categories in terms of which are at higher risk, or does it vary?
It varies across category, and again, CDC has put out the best data, on that. And again, don't have time to go into the detail, but we could provide that for the record.
I appreciate that. Also, there's been concerns that have been raised in some sections in the public about genetically modified organisms, genetically modified foods. While some have some concerns or risks, are there potentials that you're exploring for the future with regard to some modifications that would lead to reduced risk for foodborne illnesses among some of these?
Yeah, regrettably, I'm recused from working on matters related to genetically modified organisms, and so if you don't mind, we'll have...
That's fine.
Yeah, thank you.
You had mentioned that you're taking steps to inform some growers, some products of actions that they can take to improve safety. I appreciate that. Are you also providing technical assistance or support to them, in particular, to help them comply with rules?
That's a very important part of our strategy and our plan. Even well before the rules are final, we've created, in collaboration with USDA and with the State Departments of Agriculture, the Produce Safety Alliance at Cornell University, which is all about developing training and technical assistance materials for small growers. So this is central to our strategy. It's educate before you regulate is a mantra that many of us are using.
So have you been working directly with some of the growers and food manufacturers, listening and communicating with them on those?
Yes, through their organizations and directly working with growers and processors, certainly.
When a product is linked to some sort of outbreak and consumer confidence plummets, in many cases, the company that had nothing to do with the issue will see sales of similar products decline, even though they're not part of that. How does the Food Safety Modernization Act address this to prevent some single outbreak from crippling a whole sector of the agriculture industry?
No, that's a very important point, because that's why many people in industry are supporting this so strongly, because they can be affected by what others do. I mean, the fundamental thing, of course, is to prevent these outbreaks as much as we possibly can, so you don't have the loss of consumer confidence and market disruption, and FSMA will contribute to that greatly. The other piece, I think, is this effort to detect outbreaks more quickly. The sooner we can detect an outbreak and contain it, the less disruption there is, and so both of these things, prevention and response, work together.
See, now, also in addition to what's being done with growers, food processors, manufacturers, distribution, grocery stores, et cetera, what is being done in terms of public information campaigns to help all of us in our households know what should be done at home in terms of food storage, food preparation, what should be looked for on products that could tip off some ways that the food may be containing some sort of illness?
No, that's a really important question, and both FDA and USDA have consumer education programs. They're fairly modest in scale. We work with the Partnership for Food Safety Education, which is a collaborative undertaking between industry, consumers, and government. We need to do more on consumer education. It's part of the public health, prevention system in our mind. And one thing that has happened over the last year or two has been an ad council campaign, for example, that has tried to reach consumers through the advertising media. But there's more to be done to really understand how consumer education can be done in a way that does change behavior and reduce risk. We can't depend on consumers to solve the public health problem, but they're part of the ability to minimize risk, and we want to work in that way as well.
I hope so. I mean, I can't recall ever seeing an ad of any kind about that talks about some of these issues with food.
It's very limited, yeah.
And yet we're the last part there. Other than knowing, if there's a bulging can, don't open it or eat it. Or look at the date on something, or what most people do is simply smell the milk, and if it smells bad, don't have it. But other than that, I hope that that's an area, because that is an area of public outreach I think is essential for people to know that.
Agree.
All right, thank you. I yield back.
Thank you.
Gentleman yields back. Mr. Green, 5 minutes.
Thank you, Madam Chairman, and thank the Chair and the Ranking Member of the Committee for this hearing today. Commissioner Taylor, I want to thank you for being here and your patience with us. I have a district in Houston, in fact, the Port of Houston. So a few years ago, I had the opportunity to be on the docks with not only FDA inspectors, but other inspectors for our food safety. And in Texas, we have not only a number of ports that bring in, but we also have a huge land border, which brings in just untold amount of foodstuff from Mexico. Ensuring that the rules are effective in protecting public health and supporting industry best practices is critical. I believe that two of the most contentious rules you're developing are those establishing preventive controls and produce safety standards. produce safety standards. It seems to have taken a long time for FDA to release them, and in fact, it may only have been because of the court order that you were able to release them when you did. And since that release, you've delayed the close of your comment periods and announced you may be reproposing parts of each of them. My question is, considering the foundational of these rules are for establishing a preventative food safety program, can you tell us why they've taken so long to develop the release? I would hope that the proposed rules and working with the stakeholders, you realize you've gone back to the drawing board if that's part of it. But like my colleague from Texas, Dr. Burgess, you know, it has been 3 years since the law passed. Can you describe the process you've gone through to develop them, including the engagement of those stakeholders? Explain to us what makes them so contentious, and can you explain their importance to public health?
Sure. And I appreciate your impatience. I've experienced it myself, and we're all working hard to get this done as quickly as we can. We do think it's critical to get it done right. We're really laying the foundation for the next 50 years of successful food safety oversight in this country. And I think we do have enormous momentum with the 7 proposals we've published since last January. I think one reason it takes time is because these proposals do have to work together, first of all. They have to, it's like putting a puzzle together. And there are a lot of complexities among the provisions. But also, we can't lose sight of the fact, and this gets to the question of why there are, you know, we have had a very vigorous dialogue with people with different points of view. We are building a new system that affects a lot of economic activity and a lot of actors in our food system. And so understandably, people have perspectives, they have information that they want us to consider, and we feel obligated to, and we want to, because it's how we'll get a good set of rules that will work for the long term. So, you know, we feel good about the dialogue we've had. We think the process has real momentum. We're working to meet the court deadlines and balance these two considerations of speed and ability to be sure everyone is heard, and we've got the best possible rules at the end of the day.
Okay. My other concern about is improving foodborne illness surveillance is a critical part of the Food Safety Modernization Act. I've been told that foodborne illnesses are woefully underreported and that the quality of reporting varies dramatically by state. I'd like to know what the FDA is doing and planning to do to improve reporting of the foodborne illnesses. And as part of your answer, could you speak to what the FDA and CDC are doing to improve capacity at the state and local level to detect and track outbreaks?
The surveillance of foodborne illness, of course, is CDC's responsibility, and they are charged in FSMA with improving foodborne illness surveillance. We, as I indicated, work very closely with CDC on the early detection of outbreaks. But the ability to respond to outbreaks is very much a function of what state health department capacity is, because most of the legwork in a foodborne illness outbreak is done by state and local health departments, and they've suffered their own budget cuts. So there is a real resource sort of infrastructure problem in our ability to detect and oversee and then estimate the frequency of foodborne illness. And it's again, CDC manages that part of the food safety system, but we're, you know, as dependent upon and place the importance on it as much as anybody.
Well, like my colleague, our Chairman Emeritus, I'm concerned about not having the resources to do your job. And is this delay for the last 3 years now, is that because of some of the lack of resources that Congress may not have applied?
I don't know, sir. I think, you know, the time it has taken is a function of the complexity of the process, and the you know, we have deployed our people and put great.
I'd be glad to yield.
Yes, sir. Yes, sir.
And I appreciate the chair's patience. Sometimes some of us support a unicameral Congress instead of just having two bodies. Thank you for your
Can I just clarify the point that I want to make about this? Is that by redeploying people within FDA, we have, and the resources we have gotten from Congress, we can issue the regulations. You know, we can put the rules on the books where we are lacking resources and where the fees would be essential, or the additional resources is in implementing the rules, and that's where we get the food safety and economic benefit if we implement the rules the way they're envisioned and intended to have this modern preventive system. So it's that, and that's where we have the big funding gap for FSMA, is the implementation of the rules once they're promulgated.
Okay, time for the gentleman from Texas expired. I recognize myself for 5 minutes. And Mr. Taylor, we're all concerned about the implementation and what that structure would look like. Mm-hmm. And of course, a risk-based structure makes sense. But I think that what we know is that 1% of the domestically produced commodities account for 95% of the illnesses. And those commodities should clearly be the focus of any risk-based system. And I think that part of our concern is why you've chosen to broadly regulate commodities that have not been associated with human foodborne illnesses.
So let me give you a little bit of it. This is in the produce context, I think. And
yes, it is.
I do have to respectfully say I'm not sure the basis for the 1%, 95% point, but I'm happy to have dialogue about that. There's no question that there's some commodities that have been more associated with significant outbreaks that we've been able to detect and that CDC has reported than other commodities. There's no question about that. One important point is that our ability, as we've been discussing, to detect illnesses and outbreaks is limited by lack of resources. So there's great underreporting of illnesses that occur. What food safety experts recognize and what Congress recognized in passing the law is that when it comes to produce, and that if you don't pay attention to the quality of the water, the safety of the water you put on the produce that people are going to eat, or you don't pay attention to the basic hygiene of the workers handling the food, if you don't pay attention to what's happening when fertilizers are added that could potentially be carriers of pathogens, Congress identified these basic vectors of possible contamination and directed us to establish the standards that are reasonably necessary to prevent the introduction of reasonably foreseeable hazards. So it's a prevention syndrome. It's not a response or regime.
Right,
it's
and
not a response to
yes.
outbreaks, regime in FSMA. And so that
I appreciate that, but talking to my Tennessee farmers about the produce safety rule, they are very concerned with the lack of flexibility. Now, I was pleased to hear you tell Mr. Walden that you're going to do a revisit on the water rules, because you do have to take into account the regional and the local water supply issues that are there. But I think it's important, and I wish that you all would consider the relative risk and the comparative benefits associated with regulating some of these individual commodities. I will tell you, some of the rules are a head scratcher, and I'll give you an example. Kale, listed as a commodity and noted never consumed raw.
We learned through the comment process, and so that...
Yeah, well, I was going to offer to make a kale salad for you. And, so I think it's interesting. Those are the things that you read, and it causes you to wonder if those that are writing these rules have ever set foot on a farm, or if they have ever been to a Farm Bureau dinner where everyone is bringing their favorite dish and enjoyed some of these wonderful items. So I hope that listening to the questions that we're asking, that it points up some of the things that we need to be bringing to your attention.
Sure.
And through the comment period, we know that you are going to come up with some of these. I think that another thing, before my time expires, that I want to highlight with you is the factors or standards that the FDA used to establish its list of covered or exempt produce. This is something that has been questioned. is how you all came about those and what list would be regularly reviewed. So just know that all of that is on our list, and we're going to continue to conduct oversight very carefully. And with that, I'll yield back the balance of my time. And Mr. Griffith, you're recognized for 5 minutes.
Thank you, Madam Chair. Thank you for being here this morning. In the FSMA law, Congress specified that facilities should identify reasonably foreseeable hazards, but my understanding is in the proposed rules, the FDA is using reasonably likely to occur in the proposed preventative controls rule. This language is different from law and forces the food industry to shift from focusing on what will occur to what can occur. Does, in fact, FSMA use reasonably likely to occur as a basis to define the threshold for determining preventative controls?
That's not the term used in the statute. It comes from our experience with HACCP preventive controls. But again, we've heard a lot about this issue, and I think we have a way to address this.
Okay. And I just have to point out that, you know, I would have gotten in trouble. I'm not a food expert. I was a lawyer by training. But my law school professors hammered into us the big difference between the possibilities that an expert witness might testify or might not testify to, and the probability, which is a different thing. And I think that's what people are concerned about.
Yep.
You know, any of us could be hit by a meteor tomorrow. They're out there. But that doesn't mean we need to be taking evasive action when I cross the street from this building to the next.
Yes, sir.
Likewise, if there's a probability, I do need to be watching out for those cars that are coming down the road.
Understood.
And so I do appreciate that. Also am concerned, just want to make sure that I've got this clear, that, you know, I have represent a rural area of the country, and want to make sure that all my small farmers aren't getting into any kind of headaches and hassles that would close them down. It's my understanding that if you are, you know, a farmer who's growing fruits and vegetables and you're selling to, you know, directly to the end-use consumer, that unless you have sales of $500,000 a year on average over 3 years, that you're not covered by these rules. Is that correct?
That's correct.
All right, and I do appreciate that. Likewise, for people that are canning vegetables, making jams, or manufacturing honey for farmers markets and local consumption, am I correct also that they would be exempt from the preventative control rule?
If they have sales below that $500,000 threshold, yes, sir.
All right. Are there new requirements that these smaller farmers or the farmers who are selling right at their farm or at the roadside stand or at the farmers market that they would have to meet in order to be in compliant with FDA's implementation of FSMA?
For produce growers who are exempt under this provision, the only thing they're required to do, this is by statute, by the law itself, is post information about their location so that their customer, direct-to-consumer customer, can come back to them if they have a problem.
Okay. And I appreciate that. I also will tell you that I appreciated very much in previous testimony when you said that you all recognize that you can't have a one-size-fits-all approach.
Yep.
That's very refreshing. A lot of people are concerned both about that and about folks getting carried away, and suddenly we're shutting down the small farm operations. And your testimony today has made me feel better about that, and I appreciate you being here. And with that, Madam Chair, unless somebody wants my time, I will yield back.
Chair thanks the gentleman, and now recognize the gentleman from Florida, Mr. Bilirakis. 5 minutes for questions.
Thank you very much. I was over at the other hearing. Mr. Taylor, I just wanted to follow up on an earlier question. I believe Chairman Shimkus asked this about food byproducts being used for animal food. In Florida, the citrus industry sells orange peels, as you know, and oranges have fallen off the tree for animal feed. I think there are large environmental and sustainability issues that FBA may be overlooking. If the proposed rule drives up the cost of byproducts diverted to animal feed chain, many small and mid-sized manufacturers will abandon the production of feed ingredients and send the byproducts and the waste streams to landfill. This increases the load on landfills and decreases the available products for animal food feed, thereby increasing the costs. So my question is, will the FDA perform an environmental impact analysis before the final rule? And again, I want to ask this as well. Can FDA quantify the benefits of their proposal?
Sure. So with respect to the environmental impact statement, we are doing an environmental impact statement on the produce rule, and so that will accompany in parallel the rulemaking process, and we'll have that before the final rule. But on this specific issue, it's not our intent, and we're going to work hard based upon input we receive from the community to disrupt these established practices of byproducts of human food production going into the animal feed system. I mean, that's an important part, for reasons you've recited, of our food system. So it's not our intent, and we don't think from a food safety standpoint that would be necessary or appropriate. So this is the kind of issue that arises during the rulemaking, where we get comments, and I think we'll work to harmonize the produce and preventive control rules to provide, to prevent outcomes that just don't make common sense. I mean, we're guided by common sense here, and I think this is an issue that's very manageable within the FSMA regime.
Okay, very good. Thank you. I'll move on to the next question. With regard to cybersecurity, the proposed rule would require all mandatory records to be made promptly available to the FDA upon oral or written request. Is that correct?
Yes.
Okay. If the FDA requires these records to be submitted electronically and reviewed remotely, how will the FDA validate that the requests are coming from authorized representatives? And more importantly, can you guarantee that the system will be safe from hackers or leaks?
No. So the first point is that it's a work in progress, and we need to work with the industry to figure out how we exchange information in a way that is most efficient for our collective purpose of protecting food safety. And so this is something we have to do in dialogue, with the industry, including with respect to electronic transfer of records. To the extent that records are transferred electronically, we absolutely have to protect the confidentiality of records that are confidential business information. We have a lot of experience doing that with conventional records within our foods program. There's a lot of experience elsewhere in FDA with electronic submission of data and the drug approval system. So I just commit to you, there's no lack of sensitivity to the importance of protecting confidentiality of data. We have a lot of experience doing it, and it's something we'll work with the industry to be sure we do right in this context as well.
All right, thank you. My last question, Mr. Taylor, Florida has a significant number of beekeepers, as do other states. Mm-hmm. The beekeepers and honey production industries, along with others, have been victims of various illegal trade schemes perpetrated mostly by Chinese exporters. Mm-hmm. As a result of these trade challenges, a lot of adulterated products, such as honey, have entered the United States undetected. While imports are the responsibility of Customs and Border Protection, I understand that once adulterated products enter into the stream of U.S. commerce, it becomes the responsibility of FDA. Is that correct?
That's correct.
Okay. I'd like to know that what FDA is doing to combat economically motivated adulteration. FDA's proposed rule on mitigation strategies to protect food against intentional adulteration did not include economically motivated alteration within that rule, and FDA will address it under a separate regulatory scheme. My question is, could you explain to me how FSMA changes FDA's enforcement authority with respect to economic adulteration, and how it will improve FDA's enforcement over economically adulterated products such as honey?
Yeah. Good but complicated question. We will be addressing intentional adulteration for economic purposes in the preventive controls rule. It's a challenge to do that, because in that preventive controls framework, we don't want to require the processor to control that which can't be anticipated, which isn't whether you use them reasonably likely to occur or probable to occur. Regardless of the language you use, we've got to sort of focus what we expect of processors. So we had the melamine in pet food problem a number of years ago, which was one of it was imports from China. That sort of intentional adulteration for economic purposes, where you've got a past history of that problem occurring, we think can be addressed through the preventive controls rule. But but there's a whole array of economic adulteration issues that are going to have to be addressable through other means as a practical matter. And so we do provide guidance about what's appropriate in certain products. We take limited enforcement action within our resources. If it's not a safety issue, it necessarily ranks lower in our priorities in terms of deploying our inspection and enforcement resources. But there are things we can do and have done, and we know the concerns in the honey industry, and we've had dialogue and look forward to working further to.
Can I ask one quick question?
Address that.
Just to follow, has FDA, is there a national standard? Have they created a national standard as far as determining whether there's adulteration?
Well,
if they have not, why haven't they?
Well, there's not a national standard of identity that I think some people have asked us to establish that we have not done to date. There are standards that we've acted on if there are illegal pesticide residues or antibiotic residues, which sometimes happens in honey. We have taken action. We can take action under current law. We don't need any new laws or regulations to take action there. It's more a matter of being able to detect these and invest the resources to do the enforcement action.
Are you in favor of creating a national standard?
I think in concept, we see the usefulness of it. Frankly, it's a priority and resource challenge for us. And so we're looking at other ways to try to address this. And again, welcome working with the industry.
I really appreciate it, Mr.
Yes, sir.
Thanks for the testimony.
Yeah.
Thank
Chair,
you.
thanks, gentlemen.
I yield back. Thank you.
The chair now recognizes the gentlelady from North Carolina, Ms. Elmers, 5 minutes for questions.
Thank you, Mr. Chairman, and thank you, Mr. Taylor, for being with us today. I have a question about, as the rules are being implemented and the scope and the breadth of the rules, to me it's foreseeable that there may be some discrepancies, and I'm concerned, and I hope you can expand on the process that can take place. If a grower or a producer is basically disputing or disagrees with inspectors' conclusions or the interpretation of the rules, will the FDA provide a centralized, timely mechanism for those growers or processors to appeal the FDA? I don't even know. It may not have even gotten that far yet.
Well, again, we're not to the point where we have rules that we're enforcing, but we're very sensitive to the fact that in the produce arena, we're regulating on farms in a way we haven't done it before. And so we know we have to be sure our people are specially trained to understand and work in the farm environment. And we have to be very careful, particularly in the early years, that we understand what the expectations are. We've communicated that to growers, and then we make consistent decisions when we do see problems. And so there needs to be a process to connect that person who's on the farm with the subject matter experts and others who can be sure we make good, consistent decisions. The Commissioner announced just earlier this week some major changes in the way we work internally within FDA to link, our headquarters centers and decision makers with our field force in a much more vertically integrated way to address this very issue of do we have the right training, the right oversight, and making the right consistent decisions. So it's something we're very sensitive to as we look forward to implementing the produce rules.
Well, do you know, and are there plans for a basic, comprehensive or directive as far as an appeal process? If there is a dispute?
Sure. We already have processes in the chain of command through our field organization, but we think produce is going to require some special vehicles. Again, we're going to be implementing these produce rules in close collaboration with states. And in fact, we envision that it's the state agencies that would be the primary frontline interface with growers. We expect to be on farms actually to a very limited extent. We don't have the resources, and we think that the states have real advantages in their local knowledge and expertise. So how do we need to work out with our state partners. We met with the National Association of State Departments of Agriculture just earlier this week, and we're working hard with them to figure out how we will be prepared to partner with them to do this work. So there's a lot of work to do to put this implementing system in place.
Okay, so you do foresee it as a partnership rather than a jurisdictional issue, because I know we've run into that problem before.
It has to be. Again, Congress has mandated that we have a national integrated food safety system, has said that we should work with state agencies on produce oversight in particular. We're working hard to build that system. That's the only way we'll be successful, we think.
Thank you, Mr. Taylor. I yield back the remainder of my time.
Chair, thanks, gentlelady, and now recognize the gentleman from Kentucky, Mr. Guthrie, 5 minutes for questions.
Thank you, Mr. Chairman, and thank you for coming today. I have a specific question that's been brought up in my not peculiar to my district, but my understanding is that the proposed rule would apply to facilities that manufacture, process, pack, or even hold animal food. So they would be required to register it as a food facility under 415 of the Food, Drug, and Cosmetic Act if they fit that category. My understanding is. So the question is distilleries. I know alcohol is exempted from this particular section, but the byproduct. So they're not manufacturing food,
Right.
but they take the corn, they take the mash, and do their formula and distill off the alcohol. And then the remaining is actually good protein corn because they use the best corn in the world for their. And so farmers do buy that. And so the question is, would a distillery that sells their byproduct, or any, you could do an ethanol plant, you could sell their byproduct as animal food, be required to register under 415? That's a concern they have.
Yeah, the registration requirement. I'm turning to my colleague because I don't want to give you the wrong answer, and we know this is an issue in the FSMA implementation. But the registration requirement is actually established as a result of the Bioterrorism Act of 2002 and regulations FDA issued back then. But it's significant for FSMA because the requirement to implement preventive controls applies to firms that are required to register under the Bioterrorism Act. So there's a lot of interaction there and complexity. And frankly, I'll have to get back to you on whether the current provisions of our registration requirements apply to the distillery that's producing the byproduct that's going to animal feed.
Yeah, they're selling the byproduct instead of having to
understood.
discard it. Yeah, that's what they're.
Yeah. But again, I think it's an issue that has come up in the FSMA rulemaking. How does the preventive controls regime, for animal feed apply to just that sort of situation? So this is an issue that we'll have to resolve in a practical way. And again, the whole goal here is to achieve the food safety goal without imposing regulation just for regulation's sake. And so we'll have to figure out what the right practical answer is to be sure that the animal feed safety issue is being addressed in the most practical way.
Yeah, I know it's a very specific, and so
no,
getting back to me is a very fair point.
Yes, sir.
Yeah,
we'll do that.
Thank you.
Chair, thanks, gentlemen. Yields back. Chair, thanks, gentlemen. Now recognize the gentleman from Georgia, Dr. Gingrey, 5 minutes for questions.
Mr. Chairman, thank you very much for holding today's hearing. I'd like to welcome our witness, Mr. Michael Taylor, from the FDA. Mr. Chairman, I understand that our witness served yesterday as a panelist at one of the sessions of the 2014 National Association of State Departments of Agriculture Winter Policy Conference in Reston, Virginia. And the topic was very similar to what we're discussing here at this hearing. During the Q&A portion of that session, my home state of Georgia, Commissioner of Agriculture, Mr. Gary Black, pursued a line of questioning where he felt he received incomplete answers. I think it was just a lack of time. And I would like simply to follow up on that line of questioning, Mr. Taylor, if you don't mind. When do you expect the produce and preventive control rules to be finalized?
No later than based upon the current court order, than the end of June 2015. That's our current requirement legally, and we're working to meet that.
At the end of 2015?
End of June 2015. June 30, 2015 is the current court deadline.
June 30th, 2015,
I'm sorry.
not the end of June of 2015. All right, now these are kind of yes or no questions, and we can go through them pretty quickly.
Yes, sir.
Is the intent of Food Safety Modernization Act to ensure enhanced safety of all produce, both imported and domestic, for American consumers?
Yes.
Would you care to speculate what weight the law places on imports versus domestic produce production? Is it fair to say that it's 25% import versus 75% domestic, or is it equal?
Well, I think it's the same goal. We need to have the same assurances about the safety of imported food that we have about domestic food. I think when I think about where the real the innovative breakthroughs and real shifts from where we've been historically in regulation are coming, the import system is very much novel. We have experience with preventive controls in processing facilities in this country through meat and poultry, HACCP systems, what we've done for seafood, but it's a big new departure to hold importers accountable for managing foreign supply chains and to have FDA mandated to be much more present overseas. So So it's a big, imports are a big focus of the law. I would,
Well, excuse me, because I have to watch my time,
sir.
but really, again, yes or no, is it correct that the current proposed rule for produce is focused on domestic production?
No, that's not correct. Those rules will apply to domestic and foreign growers who are shipping food to the United States.
When do you plan to offer a rule on imports, and will that rule mirror the proposed rule for domestic production with respect to content and ultimate impact?
Yeah. So the proposed rule on produce safety applies to foreign and domestic growers. The proposal we published in the summer of last year on foreign supplier verification is the central rule mandated by FSMA for strengthening oversight of imports, because that.
Let me cut right to the chase here. Can you assure farmers in Georgia and across the country that they will not be placed at a competitive disadvantage with importers once both the domestic and import rules are finalized?
Yeah. That is absolutely our goal, and if we get the resources to implement the import provisions of this law, we can achieve that goal.
Well, that is reassuring. Ms. Taylor, last question, but it's a longer one. Are you familiar with what has been coined as the BASE, this is an acronym, approach for produce safety under the Food Safety Modernization Act that has been promoted by my state's Department of Agriculture? Are you familiar with that?
Not the acronym, but
BASE?
Yeah,
yeah. Well, BASE puts states in the best position to efficiently drive the program under federal regulations, thereby keeping, hopefully, the FDA off of American farms. Do you believe that this approach has merit?
We are working, yes, and we're working. It's not that we will never be on farms, but as I said earlier, I mean, we want to partner with state agriculture departments, health departments, those who are involved in produce safety at the state level, to be the front line, the primary front line presence, working with growers, overseeing growers, and verifying compliance. That is absolutely the system that we're working to develop.
Well, again, that's quite reassuring, and as I conclude, for those that might not know, BASE, the B represent borders between countries, where federal involvement in produce safety begins at the borders and the ports of entry. A represents the correct role for the FDA is to audit state programs. S represents standards set across the entire country. And lastly, E represents, and I think you just said that, Mr. Taylor, represents education for state regulators. BASE puts states in the best position to efficiently drive the program under federal regulations, thereby hopefully keeping the FDA off of American farms. So I am very pleased with your response, and I see my time is elapsed, so I'll yield back.
Thank you.
Thank you, Mr. Taylor.
Chair, thanks to the gentleman. That concludes the questions of the members who are present. There are other questions that members may have that we will send to you. Hope you will respond promptly. Hope you understand. We have a couple of subcommittee hearings going at the same time, so members have been in and out.
Yes, sir.
Thank you. And I remind members that they have 10 business days to submit questions for the record. They should submit their questions by the close of business on Thursday, February 20th. Very important hearing, very important issues, very informative. Thank you very much, Mr. Taylor.
Thank you,
We look forward to continue working with you. Without objection, the subcommittee is adjourned.